All right, so today we're going to focus on something that has completely transformed the legal profession, and that is internet-based legal research. Students who are entering legal studies today sometimes do not realize like how dramatically legal research changed once the internet became integrated into the profession. Before we had online databases and digital research, actual tools, existed for us, but it was done by spending enormous amounts of time, physically searching through the actual books and reporters digest statutes, library collections, all that stuff. So research that now takes minutes could once consume, entire afternoons. um, and the internet changed that almost overnight. Suddenly legal professionals could access cases and statutes and court opinions and regulations, legal commentary, whatever, from virtually anywhere. And that accessibility completely reshaped the daily practice of law. Now, at the same time, however, the internet also created a whole slew of new problems. Okay. So, easy access to information does not automatically mean that information is accurate or current or reliable, much in the same way that we're facing even now with AI. But in many ways, legal research became faster, but also more dangerous because researchers, now face an overwhelming amount of material that's online, and a lot of it is misleading or outdated. Um, One of the biggest misconceptions that students sometimes have is believing that if something appears online, especially if it appears to be very polished, professional, it has to be, trustworthy. And that's absolutely not true. You will have some websites that will have very, like, thorough, very amazing, legal analysis that's written up by these well-respected experts, right? And you'll have others that will contain like incomplete summaries, outdated law, unsupported opinions, outright misinformation. This is why a strong legal researcher has to learn how to evaluate these sources very critically instead of just simply collecting information quickly. Okay. This is quality over quantity. Um, Another important thing is you should remember that the internet changed far more than just legal research. Um, Modern legal professionals now use online systems constantly for communication. We use it to e-file things, for marketing, education, business transactions, case management, all of that. So attorneys, they file pleadings electronically. They communicate with clients through emails, client portals, things like that. They even attend like virtual hearings. And, we access the court systems digitally every single day. Um, the so just remember, it's while it's gotten a lot easier, it's created a whole new set of issues that modern legal professionals have to deal with. Again, the system has not always operated this way. This it was a huge, massive um, technological transformation. It's y'all. Monday did me in. Um, Transformation, and it was done within a very, short amount of time. One thing that has not changed though is the need for analytical thinking, and I can't stress this enough. Technology might speed up our access to information, but it absolutely does not replace legal reasoning. So anybody can, type words into a search engine, but those strong legal professionals know how to identify reliable authority, to interpret that legal document, or doctrine rather, to documents too, actually, to analyze, precedent, or even to determine if information is still valid. And so these are some of the things that we're going to be talking about in this particular chapter. So the internet is now woven into basically every facet of the legal profession. And the internet might be one of those things that you think of it as just a research tool, but again, we rely on it for everything. Again, going back to communication, it's one of the clearest examples because we use emails, we use client portals through programs like Clio and stuff like that. We use video conferencing, whether it's Teams or Zoom or whatever else. And then you also have digital document sharing systems. Okay. Um, Clients today often expect very immediate communication and electronic access to documents and updates regarding their cases. Okay. Courts have changed dramatically as well. Many courts now require electronic filing instead of paper filing, and COVID did a lot to change that. Before that, a lot of them were, it was permissible in certain situations. Um, but rather than physically like carrying motions and pleadings into the courthouse anymore, legal professionals often upload their filings directly into the online court systems. Here in Georgia, on the state level, we use Peach Court and we also use Georgia Odyssey. And you can look up both of them. You can actually set up an account for both of them and just kind of play with it and learn how to, look around and research and stuff like that. I will warn you that Odyssey is actually split into two different things. There's Odyssey and there's Odyssey Search and something else. But anyhow, you're if you're wanting to like look up cases, you want to look up the Odyssey Search. And the Odyssey stuff is by Tyler Host. Um, I digress though. It does create a lot of efficiency, but again, it creates new procedural responsibilities. So like filing deadlines and formatting rules, electronic signatures and technical problems, these all now suddenly become extremely important. All right. I can tell you that you might underestimate just how stressful electronic filing might be in real practice. But imagine you're trying to, submit a filing just minutes before the deadline, only to discover that, you have a system that's malfunctioning and the document, it's not allowing it to go through, or you have one that is uploaded, but it's uploaded incorrectly. Technology has created convenience, but again, it's also created this new form of procedural risk, if you will. Um, it did transform legal marketing. Law firms now have websites and social media accounts, blogs, digital advertising campaigns. Um, and I want to tell you that attorneys have to think carefully about online professionalism. Um, they definitely have to think about like confidentiality and advertising ethics. And all these things didn't exist in the same way that they do now, but there are some attorneys out there that I think are doing it up right in terms of marketing and doing like TikTok dances and stuff like that. And I'm telling you, I enjoy seeing them. It makes it so that the law, feels lighter. I might be in the minority there. Um, if you need some suggestions, let me know. I'll recommend you some lawyers to follow. Um, the education. So it's also changed significantly. So students now access recorded lectures and digital textbooks and, online databases and even, electronic court opinions constantly. So even legal training itself has become increasingly dependent on technology. Look at everything we do. We submit it all through Blackboard and, do everything through there. We have LexisNexis and Cali and all of that. Commerce. So commerce and your business transactions, those also create a lot of internet related um, legal issues involving like contracts and privacy, cybersecurity, intellectual property and consumer protection. But modern legal practice, it's going to intersect with technology constantly, even for attorneys who do not consider themselves technologically focused. Um, and of course, one of the most important uses is that when it comes to the internet is the research itself. And researchers, again, they can now access just a vast amount of legal authority online almost instantly. Cases, statutes, rules, regulations, government publications, all of them available within seconds. But again, accessibility is not the same thing as understanding. So one of the biggest challenges it's not going to be a lack of information. It's learning how to filter information, intelligently, and to identify what matters, legally speaking. So at first glance, um, internet research seems extremely simple. Essentially, turn on your computer, open the browser, type the words into the search engine, right? Everything you see on here on this slide. But effective legal research requires so much more thought than that. One of the biggest mistakes that beginning researchers make is searching too broadly. Okay. So imagine typing something vague like illegal search rights or something like that into Google. Those results may have millions of pages, ranging from like law firm blogs to political commentary to outdated articles, even, non legal discussions, particularly on social media with those armchair lawyers. Um, but strong legal researchers learn how to think analytically before they begin searching. So, for example, if a client claims that police, improperly searched a cell phone, then an experienced researcher immediately starts narrowing the issue. Remember, we ask questions, right? Was there a warrant? Was the phone searched during an arrest? Was consent involved? What jurisdiction applies? What constitutional doctrines are implicated? We ask all kinds of questions. And those are going to help to legally identify meaningful terminology. Okay. Um, Words matter. Okay. Remember that legal research depends heavily on, these terms. It's an art. It really is. Like a client may describe something emotionally or conversationally, but researchers have to translate those facts into legal language that databases and legal sources can recognize. So that's why the experienced researchers spend time organizing issues before searching randomly online. Um, Another important thing that students should understand is that effective internet research usually becomes more specialized as the process continues. So, like researchers might begin with, general search engines for like orientation, but they eventually transition into government websites, court databases, statutory collections, and even specialized legal research platforms. So, strong legal researchers don't simply just search for information, they search strategically for that information. And honestly, that's one of the reasons that legal research remains a professional skill despite technology becoming easier to use, because the real challenge isn't it, it isn't typing words into the search engine. Again, it's identifying the actual legal issue correctly and understanding what authority matters. Now, modern researchers move constantly between search engines, including government websites, databases, legal research platforms, all of that. So, understanding how online navigation works seems important, even if, technology itself feels familiar. And I'm not going to go too deeply into this, but, students today are generally very comfortable with using the internet both socially and casually. But professional legal research does require a different mindset. So researchers have to pay attention not only to what information says, but also where it came from and whether it appears to be reliable. So websites function, usually like these little interconnected pathways. Um, and once the statute is once you start looking at it, I've already told you, it's going to link to another statute, or one case is going to reference another opinion. And a government page might connect, researchers to like a agency regulation or some sort of procedural rules. But legal research online becomes highly interconnected very quickly. Okay. So that means that researchers have to stay organized while, actually, not just organized, but intentional. Okay. While they're doing their navigating. Um, Web addresses themselves, by the way, also provide clues in terms of credibility. Like government websites, educational institutions, and court pages are going to be more reliable than some, anonymous website or unsupported, commentary pages. That doesn't mean, though, I want to make this clear, it doesn't mean that every, official looking source is automatically accurate. Okay. You still have to verify that information and determine whether or not that authority that it's relying on remains, active. Um, I also want to say that just because a website doesn't appear to be credible, it doesn't look like it has as much work or time put into it, doesn't mean that it doesn't have good information. Again, just learn to figure out your sources. The internet itself, it changes constantly. You have web pages that just disappear or they get updated. You have links that stop functioning. Oh my God, I had that with one of my classes this semester where every single link, every single picture, every single article broken, every single one of them. It was ridiculous. Um, you even have things that will get moved to like a different part of a website, and it's all done without warning. But and that's just one reason why whenever you are documenting, it is best to honestly document how you got to where you are. Get that web page at the top just so you can kind of go back to it, bookmark it, do whatever it is that you need to do. Because again, online information can be very, very temporary at times. Just because it existed online yesterday doesn't mean that it's going to remain available forever. Um, Sometimes you can use sites like the Wayback Machine to try to go back and look at previous things that have been on the internet, but that doesn't hold true for everything that's on a website, by the way, too. So just wanted to throw that out there as well. Um, this is, though, kind of another major distinction between like casual internet use and like professional legal research, because again, that strong researcher is going to constantly verify not only whether that information exists, but again, whether it is accessible and it's accurate and it's current. And I'm going to stress that a whole lot this semester because this is such an important thing. um, Technology, as much as I'm technologically challenged, it really does make, you know, um, legal information easier to find, but it doesn't eliminate that need for that professional judgment or a human, because AI is still entirely too flawed to take over for us in this regard. Um, but it's really the way that it's changed has really increased the importance of those critical thinking skills because now, researchers face far more than just, what they can realistically trust anymore. One thing that some people find surprising sometimes is um, about online, legal research specifically is how much basic internet behavior affects research efficiency. So, modern browsers are designed to make navigation almost feel automatic. Most people no longer think about, you know, carefully typing things like complete web addresses. Um, and that's because the browsers recognize partial information and they attempt to predict where the user wants to go. And a researcher may type only part of a web address or they might omit, portions entirely, and that browser still locates that site, correctly. And that convenience is something that most people kind of stop noticing because it becomes very normal. Okay. Um, Another thing that you should understand is that internet searches are generally not case sensitive. So, in other words, typing words in an uppercase or lowercase is going to generally produce the same results. Um, So you don't have to like worry excessively about capitalization or anything like that when conducting just like an ordinary online search. And that may sound like a small technical point, but it does reflect something more broad about modern, internet search, research rather. And that is that technology is designed to reduce barriers between users and information. So search systems attempt to interpret what researchers mean even when searches are imperfect or they're incomplete. At the same time, students should also, be careful not to let um, convenience create carelessness. Okay. So just because a search engine or a browser makes navigation easier, it doesn't mean that you can approach, legal research more casually. All right. Again, you have to still think carefully about what you're searching, why you're searching it, and whether the results that you're getting actually connect to some sort of authoritative legal source. Um, it does become increasingly important because modern technology does often kind of give this illusion that finding that information quickly is the same thing as this being, strong research. And it's not. Good legal research still depends on things like careful terminology, critical thinking. You have source evaluations, analytical reasoning, and, you know, even that feeling that technology itself makes it feel simple and automatic. I have really nothing else to add to this page other than these are good sites for you to bookmark, for future reference. All right, so one of the most important developments in modern legal research was the arrival of the free online tools that are actually capable of searching for actual case law. And Google Scholar became one of the best known examples of that shift. Um, a lot of people are often surprised when they first realize that they can search federal and state court opinions through a free platform instead of immediately relying on some sort of expensive commercial database. That accessibility changed legal research significantly because it opened up the door for students, solo practitioners, journalists, self-represented litigants, and even smaller firms to locate legal authority much more easily than in previous decades. Okay. um, so, Google Scholar, it can be extremely useful when researchers are beginning a project or trying to locate cases very quickly. A researcher can search by name, the citation, or even general like legal concepts. So, if someone is researching, say, Fourth Amendment cell phone searches, Google Scholar may very quickly, surface some, major constitutional decisions that are connected to that particular issue. But one thing you need to understand again is that locating cases is not the same thing as understanding them. All right, so that's where again beginning researchers sometimes become overconfident. They type in a few search terms, they find a case that sounds promising, and they assume the research is basically finished. But in reality, that is often, the beginning of the analysis. One useful feature inside of Google Scholar is the ability to see which later cases cited a particular opinion. And that matters because legal authority evolves constantly. So courts may follow earlier decisions, they may distinguish them, they may criticize them, they can narrow them, and they can overrule them entirely. But those strong researchers always want to know how later courts have treated the authority that they have found. All right. And this is one of the reasons that legal research becomes more analytical than ordinary, internet research. You're not simply gathering information, you're literally, tracing like the development of legal doctrine over time. Um, Another important thing that you should understand is that Google does rank cases according to its own determination of its relevance or importance. And that sounds convenient initially. All right. But it can also become very misleading because search algorithms do not evaluate legal significance the same way that a trained legal professional does. Okay. So a case may appear near the top of the search results because it's highly cited generally, even though it may not actually control the jurisdiction or the issue that's being researched. Um, you might have, this very beautifully written opinion from another state that may sound persuasive, but again, it carries no binding authority whatsoever in your jurisdiction. So that might be a problem. And again, that's why you have these, this is why experienced legal professionals constantly ask questions. We have to ask, what court issued this opinion? Is this authority binding? Has this case been limited or criticized? And does the factual situation actually match my issue? All right. So technology helps researchers to locate that information faster. But again, technology does not replace legal judgment. Okay. One more thing that I want to add here. Free research tools often lack some of the more deep features that are available in Lexis or Westlaw. Okay, so commercial systems frequently include things like editorial summaries, annotations, integrated citators, advanced filters, and research tools specifically, used for legal analysis. It doesn't mean that the free tools are not helpful. And I want to stress that enough because it's far from it. Google Scholar can be a super amazing starting point, okay? But a strong researcher is going to understand the strengths and limitations of every research platform that they use. All right. And that's one of the biggest transitions that students make over time is learning that good legal research isn't about using one magical database perfectly. It's about learning how to combine multiple tools to validate their authority, carefully and to think critically about the information that's being located. One of the most important skills that you need to develop is learning how to decide whether or not the a website, deserves your trust. Um, and this matters far more than you might initially realize because, again, the internet creates this illusion that all information kind of exists on equal footing, right? So a polished website may look very authoritative while containing very outdated law or weak analysis or completely unsupported claims. Okay. Strong legal research, you know, is going to be done by approaching online material with professional skepticism instead of automatic trust. And I already talked about some of this, but since this brings it up, I want to kind of circle back to it. Um, Again, we have to notice, where does this originate? Where does this information come from? Government websites are going to be generally viewed as more reliable because they're often the official sources for, um, things like statutes and whatnot. Um, Regulations, your court opinions, your agency materials, all of that. Educational institutions, they also carry a lot of credibility, particularly when legal analysis comes from recognized law schools and established research, centers. Commercial websites, they might involve, different motivations. Okay. So some exist primarily to market legal services, and others are to attract traffic rather than to provide some sort of balanced, legal analysis. And it doesn't automatically make them unreliable, but researchers should understand the difference between, informational authority and promotional content, essentially. Um, Another major issue involves timing. Again, the law changes constantly, so cases are overturned, statutes are amended, regulations evolve, and constitutional doctrine shifts over time. So you might have this amazing law review, from several years ago, but it no longer reflects current law at all. All right. So, as a strong researcher, you're going to pay attention to that publication date and ask whether or not this material appears updated and current before relying on it, professionally. Um, Authorship also matters enormously. And sometimes students find legal commentary online without ever checking who actually wrote it. So, like a constitutional law professor or an experienced appellate attorney or a government agency should carry a different level of credibility than, say, an anonymous blog that's written by someone with unknown qualifications. It's not to say they aren't right, but you should still be looking at it with skepticism. You have to learn to ask not only what is being said, but who is saying it and why. Okay. Um, you also notice whether or not the source actually supports its claims properly. So, like reliable legal analysis is going to identify things like cases and statutes and regulations and other primary authority that is going to allow the readers to trace that information back to its original source. All right. Weak websites are going to make, very broad, kind of sweeping claims without any kind of citations, and or they might, rely heavily on like a vague summary that's disconnected from the actual authority. um and again, one of the biggest warning signs online is overconfidence without support, in all honesty. The internet is filled with people who are presenting opinions as settled law, when the issue is legally complicated or unresolved. Um, so strong researchers, they're going to have to pay attention to that overall quality. Obvious factual mistakes, broken links, grammatical errors, exaggerated claims, sensational language, things like that can signal a more broad reliability problem. So one visible error can often raise concerns about what other inaccuracies may exist beneath that surface. Okay. And ultimately, determining credibility online is about learning how to think critically rather than passively, just consuming information. So, like, the strong legal researcher is going to constantly compare their sources. They're going to verify that authority, and they're going to evaluate whether information actually deserves reliance before incorporating it into legal analysis. All right, so again, strong legal researchers eventually learn that credibility online is often revealed indirectly rather than kind of just announced openly. Okay. You can have a website that looks so polished and so professional while still giving you very weak legal analysis. Okay. It can give you outdated information, unsupported claims, all of that. At the same time, there's some very highly reliable legal sources that may appear very visually simple, because their focus is on accuracy rather than presentation. So that's why experienced researchers stop paying attention only to appearance and they start paying attention to that substance. Okay. Um, Another thing that I want to add here is, and I meant to add some of this on the other page, so you'll have to forgive me because my notes are kind of all over. Um, it can be very mentally exhausting when it comes to screen reading. All right. A lot of people assume that digital reading is easier because material is immediately available, but comprehension often actually drops when researchers spend very long periods of time, scrolling through um, online sources without pausing to analyze what they're actually reading. So you have to slow yourself, and I mean slow yourself intentionally. All right, stop, summarize, compare authority, and think critically about whether the information actually answers the legal issue that is being researched. All right. Another thing to add is about false completeness. Sometimes students assume that if they can't find something online quickly, it may not exist. All right. That assumption can become very, very dangerous. Some legal materials remain difficult to locate electronically, particularly like older authority, something that's like highly specialized materials. Adoption's a good example of that. And local resources. Okay, so strong legal researchers understand, yes, the research internet is powerful, but it's not necessarily complete. All right. Currency is one that I meant to address on the other side. So again, websites change all the time. Pages disappear. Again, those links stop functioning. Statutes are amended. You have court opinions that are updated. Um, you have to develop habits that are designed to keep information both current and traceable. All right. So you're going to need to subscribe to updates, that involve legal developments in that particular practice area, because again, the law is evolving continuously. Constitutional doctrine changes, agencies issue new regulations, courts reinterpret statutes. So you have to stay current, and if you fail to do so, you can, accidentally rely on outdated information without actually realizing it. Um, One of the most important things that I think you can develop is healthy skepticism. I meant to add this up above as well. Again, sorry, my notes are kind of all over the place, but it's only for this section. Um, so you might have something that sounds so persuasive, but it completely misunderstands like the governing precedent that's being talked about. All right. So please, please, please do not trust information automatically simply because it appears very confidently online. So, a mistake that people make online is assuming that because something is easy to access, it's also free to copy or to reuse however they want. And that assumption creates serious problems in legal research and professional writing because much of what the um, researcher is going to encounter material wise online is still protected by copyright laws, even when it appears publicly available. So, like articles, charts, legal analysis, blog posts, graphics, educational materials, they often belong to people or the organizations that created them. And sometimes students will fall into the habit of copying online material very casually because digital information feels very informal. So a paragraph can be copied in seconds, it can be pasted into notes and then reused so easily that people stop thinking carefully about ownership and who it's going to be attributed to. But it doesn't mean that it removes those legal protections for the people who own it. Um, so again, you have to be very careful about the information is being used when it has been created by someone else. So if you rely on someone else's language, their analysis or their interpretation, they identify where the material originated. Okay. So proper attribution is not just an academic requirement. This is going to reflect your professionalism, your intellectual honesty, your ethical responsibility. All right. Another thing you should understand is that you simply cannot, repeat online information without independently verifying it. So if you copy some weak or inaccurate legal analysis into some memorandum or a motion, it can create very serious problems that are way bigger than anything could come by way for plagiarism alone. All right. Competence becomes an issue too. You as a legal professional have an ethical obligation to ensure that the authority that you're relying on is both accurate and current. Okay. And honestly, that becomes very increasingly important in the modern internet environment because misinformation spreads very quickly online. All right. People will very quickly repeat legal claims very confidently without understanding the underlying law at all. All right. Um, so, strong researchers are going to learn how to trace statements back to the actual authority instead of relying on summaries or unsupported commentary, period. Okay. And again, we respect the intellectual property of others, period. All right. Legal scholarship, research guides, articles, educational resources, we don't care what it is. These represent enormous amounts of effort and expertise. All right. So, as a professional researcher, you should recognize that value and treat those materials carefully rather than assuming online access eliminates ownership rights. All right. Because ultimately, ethical internet research requires more than simply avoiding plagiarism. It requires them to think carefully about, accuracy and attribution and professionalism, and again, respecting the work of others. So, I think one of the most important developments in modern legal research has been that push toward making legal materials publicly accessible online. For a long time, meaningful access to case law depended heavily on physical law libraries or, commercial databases like LexisNexis and all that. And those are really expensive. It created real barriers for smaller firms, students, journalists, again, those who are self-represented, or even just independent researchers, because again, those subscriptions are very costly. And sometimes you'll have barriers that deal with like travel getting to and from those legal libraries. So modern technology changed that dramatically by allowing courts to and organizations to publish legal materials electronically. So federal courts now give you electronic access through systems like Pacer, which allows users to review court filings, dockets, and opinions online. All right, so researchers no longer need to physically stand inside of a courthouse searching through, paper files to see how the litigation developed. They can examine the pleadings, the motions, the judicial opinions, and the procedural history digitally from almost anywhere. Okay, at the same time, students are very often surprised that systems like Pacer do not necessarily feel simple or intuitive, and they don't. System was designed primarily for legal administration and record keeping rather than convenience. So users have to register. They will have to navigate the procedural systems very carefully, and sometimes they will have to pay, fees in order to retrieve documents. On Pacer, you get $25 every quarter free. Anything above that, you pay for. Um, so that experience reminds researchers, that the legal system often does prioritize accuracy and um, formal procedure over the ease of use. Additional public access projects kind of came from this because a lot of people believe that legal information should become easier and less expensive to access. So you have resources like GovInfo, Court Listener, Recap, um, and the Case Law Access Project that were developed in order to improve public availability of the judicial opinions and the court materials. So those projects reflect a more broad belief that citizens in a democratic system should reasonably be able to read and examine the laws and judicial decisions that govern them. Okay. But one thing you have to understand is that, this access to this legal information, and again, understanding the legal information are completely different things. So you might successfully locate a statute or a court opinion, but you may still very much misunderstand what that authority actually means, or whether or not the case remains valid, or how the jurisdiction affects the analysis, or even whether or not precedent, later changed the doctrine. And again, the distinction between knowing how to find it and knowing how to understand it matters a lot. And I can't stress that enough. I will keep coming back to that. Um, but technology made, legal materials easier to locate than at any other point in history so far. And I suspect it's only going to get better. But again, it's not going to eliminate the need for professional legal analysis. All right, it's just not. You have to understand the hierarchy. You have to understand precedent, stare decisis, and jurisdiction and procedural posture, and validation of claims. Um, so you're going to do more as a legal professional than just simply retrieving information. You're going to be interpreting it, you're going to be evaluating it, you're going to be organizing it, you're going to be analyzing it, right? All of this has to be done very critically before it gets relied upon. All right. And that's one of the reasons why legal research remains such a valuable skill despite these technological advances, because the challenge today is no longer just finding information, it's understanding that information, and whether or not it matters or whether it deserves, the trust in whatever it is that you're doing. The internet changed legal research so dramatically that the younger people often have difficulty imagining like what everything looked like before this became the standard. And again, years ago, we had to walk through, the snow barefoot, to get to the law library. Just kidding, but it did feel that way. But they would spend hours walking through, shelves and pulling reporters and locating digests and checking supplements and manually tracing citations. All right. So if a library did not carry the resource that you needed, um, research slowed down immediately. Okay. Today, a researcher can sit there on their laptop at midnight. They can access the cases, the statutes, the court opinions, all of that stuff within seconds. All right. And that transformed the pace of legal work. Um, One of the biggest advantages is also flexibility. So, legal researchers no longer need to be tied to a specific physical location just to conduct meaningful research in most cases. There are some small courts that are still not available online. So, if you end up working on a case that involves one of those, you might still be tied to an actual, location. But, attorneys can review authority, while traveling, and judges can examine briefs electronically, and students can access legal materials remotely. All right. Researchers can monitor legal developments in real time, instead of waiting for printed updates to arrive, days or weeks or even months later. Um, the internet has also expanded public access to legal information, in ways that kind of changed expectations about transparency. So court opinions, statutes, regulations, your governmental publications, they all became much easier for ordinary citizens to locate. And in a lot of ways, that helped to kind of demystify portions of the legal system because people no longer needed specialized physical access, simply to read legal materials themselves. All right. Um, that's kind of been, a downfall as well, but that has to do with them passing it around without knowing what they're talking about, which takes me to the next advantage, and that involves speed. And breaking legal developments, they can spread almost immediately, just like, anything that goes viral that's a misunderstanding, people will latch onto it and spread that around. Um, but like when the Supreme Court, issues a major constitutional opinion, researchers across the country can begin reading and analyzing it within minutes. All right, so that kind of immediate access would have been unimaginable in earlier generations of legal practice. The internet has also changed professional communication. So legal professionals can now exchange drafts and discuss legal developments. They can share research and collaborate electronically way more efficiently than traditional paper correspondence ever allowed. So research became more interconnected and collaborative because information travels so quickly online. At the same time, one thing that as a strong researcher you should understand is that, again, convenience does not automatically equal understanding. So it might be easier to access, but you still need those analytical skills to determine whether what you're reading is reliable, whether it's current, and whether it's legally meaningful. All right. Yes, the internet, improved access dramatically, but judgment remains what separates the professional legal researcher from simple online searching. All right, this is our last one. So let's talk about the disadvantages. Although it has transformed it in very positive ways, it's also created problems that you have to learn how to manage carefully. Again, the first thing that I'm going to go back to is the illusion that information is automatically reliable simply because it appears easy to access, right? Um, People will often locate a case online, assume the research finished, and they don't realize necessarily that the opinion is no longer current law. All right, so courts regularly limit, distinguish, they criticize, and they overturn prior decisions. So, again, a case that appears online today may be legally weakened or no longer controlling at all. You have to verify. Um, and that creates one of the kind of central challenges of modern legal research. You are surrounded by an enormous amount of information, but not all of it deserves trust. Okay. So you got to have those discernment skills, sharpened. Another major issue does involve context. So legal materials that are found online, they're often disconnected from that more broad procedural, like and doctrinal framework that surrounds them. So a person may read like a single paragraph from a judicial opinion without understanding the underlying facts, the jurisdiction, the procedural posture, and maybe even how the case was later treated. And that kind of incomplete research can create very serious analytical mistakes very, very quickly. Um, People often, will underestimate um, how unstable online information can be, again because it's temporary. Websites disappear, links stop working, articles get revised, and online materials, they move constantly. So a source that existed yesterday, I can't harp on this enough either, it may not be accessible tomorrow, and that does become very frustrating during a long-term, research project, because you might struggle to relocate the material that you had relied on earlier if you failed to document those sources carefully. Um, the whole concept of being anonymous on the internet. This allows people to present themselves as experts. They're knowledgeable, right? Whether or not they possess any kind of legal expertise. All right. So you'll encounter blogs, commentary pages, social media discussions, online forums, and it's filled with these very confident legal claims that might be incomplete or misleading or entirely inaccurate. All right, so strong legal research is going to mean that confidence online. You recognize it's not the same as credibility. Um, Oversimplification is another very dangerous aspect of internet research. Legal issues are often very complicated, they're nuanced, and they're heavily dependent on jurisdiction or procedural posture. And online summaries sometimes reduce very complicated and constitutional or statutory questions into very simplistic statements. And these statements sound definitive while ignoring very important, limitations or exceptions. So students who rely too heavily on oversimplified summaries may completely misunderstand how the law actually operates in practice. Okay, so the speed of the internet research, it's become a disadvantage. Again, you have information that appears instantly, but researchers often move way too quickly. Hold on. I'm sorry, I got interrupted. Somebody came to my door. I'm on campus today recording. Um, Information does appear, instantly, but um, researchers do sometimes move too quickly and fail to analyze what it is that they're reading. So they'll skim it instead of actually studying it. They'll collect the sources instead of evaluating them. And you have to learn how to slow down enough to think very critically about the authorities that you come across rather than just accumulating information. Remember, it's quality over quantity. Um, and that's pretty much it for this particular chapter. Please let me know if you have any questions. Bye.